Let me tell you about another client of mine. He's a hardworking young guy at a golf course trying to get his feet off the ground. And one night he was out driving, coming from a concert, and there was terrible weather. It's dark, rain, wind, and lo and behold, there's a giant tree that had collapsed into the roadway. He's driving along in his BMW when he runs over this tree. BMW then automatically alerts the police that a collision had occurred. The police show up and they meet with him. The police think he's a little out of it, doesn't seem quite right. They assume he's under the influence of alcohol. But what they don't realize until later is that he has whippet canisters all over the inside of his car. And they fail to investigate any type of a DUI drug scenario. So they arrest him and they take him to the police station where they're gonna ask him to submit to a breath test. He submits to the test, but there's an error message on the breath test, detecting possible interferent from a volatile chemical. Well, this alerts the police that this person may have some type of medical issue, so they take him to the hospital. He gets treated there medically. Months later, the prosecutor gets a search warrant for his medical records. In those private medical records, doctors talk about his admission to being a regular drug user. They talk about his blood test results and what is included there, presence of drugs and alcohol. And the prosecutor feels confident that they can prove a case based on these medical records. Well, we filed all kinds of legal challenges in the case. The matter got scheduled for trial, and right before trial, we were going to argue these motions. Well, maybe 3 days before that trial date, the prosecutor hit me with those medical records. She said they were voluminous. I thought they were standard, and she did not feel prepared to present the case. I announced ready. She asked for a continuance and I objected to her continuance, forcing her to be ready, which worked out to our client's benefit. She wasn't ready to prosecute the case, and the judge would not allow her a continuance, which resulted in us closing a very comprehensive DUI situation between DUI alcohol and DUI drugs, and DUI combined influence alcohol and drugs, to one charge, failing to remove a vehicle from a public roadway. In this next video, let me tell you about a client whose case we got reduced from DUI to reckless driving, and maybe even more importantly, preserved his ability to remain in the country here on a visa status.